A judge denies bid to block Trump administration from placing USAID workers on leave. This is being reported by CBS. Washington, a federal judge on Friday declined to block the Trump administration from putting thousands of employees with U.S. Agency for International Development on administrative leave and recalling others from overseas, clearing the way for President Trump to resume his efforts to overhaul the agency as part of his plan to slash the size of the federal government. I do think that it's a good idea to do these things, but I think the real tangible results when it comes to the significant changes of USAID are going to be the fact that the left doesn't get doesn't have the access to federal money the way that it used to.
No, I mean, so first off, this is a big W for the Trump administration.
Yes.
Right? Like, let's get that out of the way. This was something that one of the cases where there had been a temporary restraining order put in place. And, you know, I'd followed a lot of these cases. This Judge Nichols, you know, I've got a friend named Bill Shipley who is heavily involved with J6 defendants. So he actually was in front of Judge Nichols a lot. And he was saying, everybody's getting really mad at Judge Nichols over this particular injunction. He was like, give him a second. He's a really good judge. Like, there's a reason. I think you're going to end up winning pretty quickly here. And that's what's happened. USAID, you know, or these labor unions try to say it's like, well, you can't cut people off from USAID in foreign countries because they need access to like foreign alerts about danger in their country. Nope. And he's like, well, okay, I'll give you like 5 days to demonstrate that that's true and like that you're actually entitled to like not get fired. And 5 days later, he's like, nope, we can fire you. Actually, they can go ahead and do what they want. And that's what's happened here.
Do you anticipate that there will be another challenge to this from?
No, I think this is going to be the end of this particular case of the U.S. I think that, you know, this is, you have a judge, you've lost your attempt to get an injunction to stop, you know, Trump from putting all of USAID basically on administrative leave and telling them all that you get to, you know, you can sit at home for the next 6 months until your salary, until we finally fire you. And I just don't think that once this ruling's been denied, they're not going to go to a different judge and try and judge stop here. Like a new judge will look at it and be like, you already filed this case in DC. It's already been resolved. No injunction. So I think that this is just a straight W. There's a lot of different ones of these injunctions all over the country, obviously, where, you know, liberals are trying to lawfare and stop Doge and stop, you name it.
That's my broader point is I wonder there's been a discussion that we've been having around the table here about what the goal of the Trump administration is and about trying to return the power to the executive and get it away from the bureaucracy, and that was one of the reasons why he's trying to do the birthright citizenship, because that should go before the Supreme Court, and that'll really bring the question, does the executive have the authority to fire people that are in the bureaucracy or not? And I wanted to get your thoughts on that.
I think the big case, and I think in the next,
and how does
probably
that pan
early
out?
Next week, because it's Friday, right? So there's nothing going to happen in the next 2 days, but probably Monday, Tuesday, I would expect the Supreme Court's going to rule on the case that's before them. I think it's the first one, which is Trump fired the head of the Office of Special Counsel, I think a guy named Dellinger. Dellinger went to the D.C. District Court, got an injunction saying, you need to keep the Trump administration, are not allowed to fire this guy. And that went up on appeal, and the D.C. Circuit Court said, well, it's a temporary restraining order. We don't meddle with temporary restraining orders, because the idea being you don't need to appeal them because they're going to expire in 28 days on their own terms. But the administration has gone to the Supreme Court and said, no. Judges do not get to tell us who to hire and who to fire. And they can't use temporary restraining orders to deny us the ability to fire people for a month. That would be that's a ridiculous interference with such an obvious core Article 2 power that, like, not even a temporary restraining order should be allowed to stay in place. And so that's already at the Supreme Court, right? Like, there's already been briefing. We're probably going to hear about that Monday, Tuesday. I expect the Trump administration is going to win. And if they win that, they might essentially win a huge knockout to a slew of these temporary restraining orders, basically saying, like, the Supreme Court's either going to, you know, take a wider view of this or just put in some dicta, basically saying all these temporary restraining orders have gone wildly beyond the judge's authority. People need to stop messing with the executive branch, period. and stop.
Some of the things that I've been hearing people discussing when it comes to this kind of stuff, even when like FDR was making massive executive orders that really changed the structure of government, there were no federal judges that were just saying, well, we're going to throw an injunction on this and stop it. And this is really kind of an innovation that's started, I guess, in the 60s, but really took off in the Barack Obama administration. Can you speak to that?
Yeah, so the idea of a nationwide injunction, it's not obvious at all that judges should be able to issue injunctions beyond the parties to the litigation directly in front of them. A good example of this, I think there was a case in Florida where the state of, I think DeSantis was trying to like ban puberty blockers or something, and they went to sue him, and in federal court the injunction was crafted so that DeSantis was not, while the case was being resolved, DeSantis was not allowed to prevent these two specific people from getting puberty blockers. He can enforce the law broadly, but he couldn't enforce it to them. That's the normal understanding of like what power do district courts have? Well, they have power over the litigants in front of them. They can say, you don't do this to this person until we've settled your dispute. So the idea that an injunction could be just broad and affect everybody in the country, despite the fact that not everybody in the country is in front of the court, it's not obvious that should be allowed, and especially given how aggressive some of these district court judges have been. I mean, there was the New York case where Judge Engelmeyer told Doge that they weren't allowed to access Treasury data. I mean, they were straight up telling it created this artificial distinction between political and career appointees, and it's like the political appointees, are not allowed to see this data. Like, whoa, what? This is a democracy. The political appointees are the people who are appointed by the elected president of the United States. The civil servants do not have some bestowed grant of authority from our government. So that was bizarre. There's been so many bizarre ones. And I think in general, what you're going to see, I mean, I know Justice Thomas has talked about tailoring these down, and basically, way too many judges are getting way too quickly involved in the workings of the executive branch. I think that it's time for that to stop. I think it's personally time for that to stop as a normative claim, and I think it will stop.
Is that where I hear so much about the term and the concept of activist judges now? Is that just because it's all become so heavily politicized? Like I've heard a lot of people discuss about the idea of the Supreme Court wasn't always seen as something that was politically biased, but rather something that was just supposed to be about interpreting the Constitution. Now you expect most of these cases a lot of the time to fall along party lines.
Well, generally, yes. I mean, I'm probably biased in my assumption, but I do think that the argument that the conservatives or the textualists are the ones that are correct in their understanding. You have to go by what the words on the paper mean, and you can't infer meaning. So even though it's the conservatives that are the textualists, and I would be, my political opinions align far closer to conservatives than to progressives, I do think that is the true thing. The other side of the argument is the Constitution is meant to be interpreted, and so the meaning will change. But I find like there's arguments made by like Judge Napolitano that says things like if the Constitution if it doesn't mean what it says, then it doesn't mean anything. It either means what it says or it doesn't, and if it doesn't mean what it says, then it doesn't mean anything at all. Or things like if the Constitution was meant to be interpreted, then the framers would not have put an amendment process into the Constitution that is not only there so that way you can change it, but also arduous and very difficult. Like the reason that the amendment process is arduous is because they didn't want you to just change the meaning of the words on the paper based on what is popular at the time.
Yeah. I guess I just think of it from a media framing device, which is that we talk about Soros-backed DAs or Obama-appointed judges or Trump-appointed judges, which is a tool that both sides of the aisle's friendly media apparatus uses as a way to frame their arguments when they're covering a story.
Yeah,
I just want to you've actually sort of landed on a very interesting, bigger debate in American constitutional law, and the question of it almost goes to should we even allow judicial review? Right? That's not obvious. We treat it as obvious that our Supreme Court can weigh in on the constitutionality of laws passed by Congress and can overturn them. It's not obvious that you have to allow that to happen, right? You can just say that all the court's job is only to, interpret the laws passed by Congress and then see if people's behavior conforms to it. But and then that connects to the question you're also talking about, which is like, okay, when exactly did judicial activism start, and what is judicial activism? That's, query whether or not like some of our most famous cases that most people would think of as the best cases the Supreme Court has ever decided weren't in fact very activist. So Brown versus Board is a sort of classic example of this, where, there's 80 years of precedent saying separate but equal is okay. And the court just decided, nah, changed our mind. And, was it super principled in terms of like, if you read the legal reasoning, or you're like, man, this is just a masterpiece of legal reasoning. Nobody could poke any holes in their argument here. No, you could poke some holes in how they got from how they just threw out 80 years of precedent. But I think nobody wants to see Brown versus Board of Education overturned. We all agree that, racial discrimination is bad.
So it's reflective of society at the time.
It can be. I mean, these things are, I think conservatives always want, I think, and I'm sympathetic to this, the idea that you want it to be black and white, but the project of interpreting text and understanding meaning there's always some amount of gray. Like, language is not computer code, it's not perfect. And I think in general, the idea the conservatives have the better of the argument that in a world where you completely go to language is totally indeterminate and it can just mean whatever we want it to mean, then basically you're saying that there is no constitution and it's just a pure exercise of power. I don't think that's right. But I think that, we shouldn't overstate the extent to which this is actually a black and white problem consistently.
Yeah, and to your discussion about it's just language, it doesn't matter. It's just an exercise of power. That is kind of the furthest postmodernist leftists. That's a fundamental belief that they have, that there is no, like, that discourses are only an exercise of power, that the words that you say don't really mean anything, and that's actually where the foundation for the everyone's a Nazi kind of comes from. The important thing isn't whether or not they're Nazis. The important thing is, do you convince the people listening that they're bad people? So you use whatever hyperbole that you want. And these are arguments that are made by people, I think it was like Foucault and Sartre and stuff like that, that it doesn't matter what you're saying, just that you're convincing the people listening.
It's really easy to understand why that tactic became so popular as phones became more commonplace and our communication went digital, which was that those bludgeoning arguments of name calling and categorizing you as something abhorrent became far more tactical when everyone was now connected via social media, and they could use that as a way of silencing people they disagreed with, because people weren't used to having those types of things hurled at them by people they didn't know.
Thanks for checking out this clip from Timcast IRL. Make sure to watch the show live Monday through Friday at 8 p.m. Subscribe to this channel, and we will see you all there.